NBC's Ryan Nobles is on Capitol Hill for us. Also with me, former federal judge and president of Dickinson College, John E. Jones, who signed on to a letter along with 75 judges urging the Senate not to advance that nomination. Ryan, what the heck happened there?
Well, Chris, this basically was the Democrats doing everything they possibly can to slow down what will ultimately be an inevitable conclusion. Emil Bovee has the support of Senate Republicans to ultimately earn this lifetime appointment, but Democrats are vehemently opposed to his pick for a wide range of reasons. So they attempted to slow down this process by essentially filibustering this judicial hearing to try and prevent a vote on the nomination. And then when Republicans just decided to sidestep all of their attempts to slow the process down and just vote right away, they got up and left en masse, attempting to try and prevent a quorum from being held so that the vote could ultimately be reported. Now, Republicans believe that this vote has gone through, that it was a 12-0 vote. It will now head to the Senate floor for a final call. But Democrats argue that they did not go through this process the correct way. So they've now appealed to the Senate parliamentarian to make an official ruling as to whether or not this nomination has been reported out. But keep in mind, Chris, that even if the parliamentarian rules in the Democrats' favor, it's just going to go back to the committee, and the Republicans are going to continue to hold their ground until eventually Democrats give up and they get this particular nominee voted out and reported to the Senate floor. But Democrats, they want more. They want to hear from a whistleblower who's talked about Bovee's time in the Department of Justice, the role that he has played in removing people who prosecuted the January 6th defendants out and pushing them out of the Department of Justice. They want to hear from that whistleblower in an open hearing. At this point, Republicans have rejected calling that individual as a witness. So Democrats have not given up the fight here, but it is important to point out that ultimately Bovee looks to be headed toward confirmation. Chris.
So, Judge, I want to get to your letter to the Senate in a moment. But first, what do you make of the Democrats' reaction to being denied hearing from a DOJ whistleblower who apparently has a lot to say about Emil Bovee's tenure at the department?
Well, I watched the hearing this morning, Chris, and it wasn't exactly profiles in courage from the standpoint of the majority of the committee. I think fairly the whistleblower should be heard, but there are other issues besides the whistleblower, which he's tended to garner some focus. But I think, you know, having served on the federal bench, and I was designated to the Third Circuit Court of Appeals on a number of occasions. I sat with that court. I have an idea what makes a good judge. I just believe, as the other signatories to that letter do, that he is singularly, Mr. Bovee is singularly unqualified to sit on that very distinguished appellate court. There isn't much question in our minds. So it's not just the whistleblower, but it's a lot of other things as well.
Well, the letter you signed on to with those other former federal judges argues that advancing the nomination would set a dangerous precedent. I want to read from the letter. It says, the Senate's role in providing advice and consent is not ceremonial. It is a safeguard against precisely this kind of erosion. Can you go a little further? Tell us what you mean by that erosion.
Well, look at what's happening now in the confirmation process, and echoing what Senator Booker said today in an attempt to implement a rule and continue debate. You're seeing things ram through. Now, is it a question of the president looking over the shoulder of the Republican senators or a lack of courage? I don't know what, but you know, you have now a letter with hundreds and hundreds of Department of Justice, former employees, prosecutors, the judges who signed, along with me, the letter, all those things that were introduced in the record. And it's like it didn't even happen. And we didn't do this in a fanciful way or in a way, you know, just to make a point. We truly believe that this individual is unfit to be a judge. Now, you would think that there would be a duty of inquiry on the part of the committee to talk to some of the folks, you know, who signed these letters and to understand better why this opposition has arisen. I'm just struck by the unnecessary speed of the process, which could only, in my view, and I'm not naive about politics, believe me, but it can only be attributable to a desire to just ram this thing through before something else develops that could be problematic for this nominee.
Well, let me read from that other letter you mentioned. 900 former DOJ officials warning against Beauvais' nomination, saying he had disgraced the department. Quote, "We are all alarmed by DOJ leadership's recent deviations from constitutional principles and institutional guardrails. We also share a grave concern over the senseless attacks on dedicated career employees who are the backbone of the department. Emil Beauvais has been a leader in this assault." If he gets a lifetime appointment, what do you see as the larger ripple effect here?
Well, the larger ripple effect is that nominees who heretofore, before this administration, would have been not just not confirmed, but their nominations would have been withdrawn, now come to the fore and very likely, at the will of the president, are going to be rammed through, which again goes to the point you just made that was in the letter. That advice and consent is not something ephemeral or that is to be lightly taken, but it is a real responsibility. And Chris, I'll tell you something else. You know, there's been a lot said about the prosecution of Mayor Adams in New York, and the fact of the matter is that what you need to know about that is that Mr. Beauvais and his colleagues wanted to basically have the United States drop that prosecution, but without prejudice, meaning that the sword of Damocles would be above the mayor's head, and if he quite clearly, if he didn't toe the line and do the immigration things the administration wanted, they could re-prosecute him. Now, the judge wouldn't allow that ultimately, but that gives lie to their claim that that prosecution that was pulled down was highly irregular. That is not the proper use of the Department of Justice. And I shudder to think, as we go forward, with the incalculable damage that's been done, and all these folks have been fired from January 6th and the Adams prosecution, you know, what's going to happen here? This is a very, very difficult course, I think, that we've chosen from both a judicial and a prosecutorial standpoint.
Former Judge John Jones, thank you.